Now, as we started talking about, we have collectors and then we have what's called original creditors. Original creditors are people who extend credit, like the veterinarian or the furniture store or the auto store. Anywhere someone extends you credit for a service or a product, they are known as original creditors. Now, the collections law wasn't designed for original creditors. It was designed for third-party collectors. However, all the state laws address people doing collections within their state. If you are in one of the 20 states that says we're going to follow the Fair Debt Collection Practice Law, regardless of whether you're an original creditor or not, then you are bound by not only the federal law, but the state version of the federal law. Now, in your book, if you look in your workbook, on page 5 and 6, it shows you a list of the states that have actually decided to follow the Fair Debt Collection Practice Act. Now remember, when you follow that act, you also must follow the state laws. Not only the state that you're in as your organization, but wherever that customer's at, you must follow that state too. Now remember also, collections law was not made for business to business, but there are certain laws that apply to collecting with businesses, and we'll talk about those. Okay? So, back on page number 2. Let's look at some information here on page number 2. You'll see where I have outlined or highlighted in orange, it says collections performers. As I go through the lessons, instead of saying collector or original creditor, I'm going to say collections performers, because it doesn't matter if you're an original creditor or you're a collections agent, third-party collector, debt collector, you have to follow credit and collections law. All the states, again, have their own laws, and there's also, the website is in the book on page number 6 that shows you that. All the states have their own versions, so you got to follow those versions. And for most of us, we also got to follow the Fair Debt Collection Practice Act. Okay. Now, so if you look in your book on page number 3, we start talking about, and this is some information I left for you to fill in. All right, collections laws are created by, and of course the answer to that, which goes in that blank, is Congress. They were created by Congress because Congress believes we can collect our money and treat everybody with dignity, respect, and honesty. And I can assure you that is absolutely right. As a matter of fact, you're going to collect a whole lot more money, a whole lot easier, if you actually treat everybody with dignity, respect, and honesty. If you're watching this lesson, then I know there's days when you had to collect your money that you told yourself, I would rather be anywhere else. Collections, when it's not done right, it's full of conflict, confrontation, it stresses you out. You go home and you want to kick the dog. When people come around, your family, the people you love, after a bad day of collections, you don't even want to talk to them. You are OD'd on people. You've had enough people for today. So collections is very important for us, the collectors, that when we collect money, we do it in a manner where it doesn't stress us out, where it doesn't make us OD on people, where we can still look at people and smile. And that's all technique, and that's a lot of what we're going to talk about. Not only the law, but that technique, so we can be effective. If you look at the second line, it says, they were created, they being the laws, to protect, or actually to regulate in this case, third-party collectors are also known as debt collectors. That's what the Fair Debt Collection Practice Act was created for, is debt collectors. They were created to protect consumers or individuals. Remember, the laws are not to protect businesses. Business to business, Walmart doesn't need your protection. If you had Walmart as a customer, in other words, if you were a vendor or supplier and you had Walmart as a customer, would you call Walmart and read them the riot act? Or would you call Walmart and say, hey Bob, how you doing? You know, how's your kids and your family? Good. You know, I was going to be over in your area this afternoon. Thought maybe I'd come by, buy you lunch, right? Are you going to, and you say, well, maybe I can pick the check up, I'm over there. Are you going to kiss up to Walmart, or are you going to try to tell them what they're going to do? Now, we both know if you lose that $100 million account, you are not going to have to worry about collections anymore. So businesses don't really need that. This law was invented for consumers because they don't have the power just to go somewhere else or hire attorneys and things that businesses do. Now, they were created in the year 1978, they being the laws, which are the Fair Debt Collection Practice Act, and that's where all these other state laws came from. The laws are enforced by the Federal Trade Commission. The Federal Trade Commission. That's who are the overseers of these laws. Now, let me say something here. About 5 years ago, a little bit more, remember up until this point, the Federal Trade Commission really didn't go out and look for violators. So about 5 years ago, with all the banks and the mishaps and banks breaking not only the collections laws but lending laws and all these different things, the Federal Trade Commission created a group called the Consumer Financial Protection Bureau. The Consumer Financial Protection Bureau. Now, this group is basically a group now where instead of a violator having to sue somebody, or somebody sues a violator, and then it goes before the court, and then the judge finds this person who does what they want to do. Now, the way with the Consumer Financial Protection Bureau, they can go out and they can fine you on the spot if they see you breaking the law, no matter where you're at. For instance, let's say you've probably all seen, like, you go into a restaurant and over on the wall they have a wall of shame where they have NSF checks from people, you know, and they put them there to embarrass the people. All right, collections law. You cannot have any kind of wall of shame. You cannot have a list anywhere that actually says these people are deadbeats, these people are past due, these people don't pay. You couldn't even have it in your office. Now, you could have it in a drawer somewhere, and we refer to it because these are people we're not going to do business with, or we're only going to do business with in a certain way. But you couldn't have it posted as these are listed deadbeats. That would be violating the law. So when you go in a restaurant and you see a wall of shame over there with NSF checks, or a little convenience store and you see that, that's breaking the law. This is the kind of thing that the folks in the Consumer Financial Protection Bureau, they're able to walk in and say, $1,000, get it down. They now have the power, and they were created to go out and find violators of collections law. So you and I, as collectors, as we're going to talk about here in just a minute, it is really in our best interest to make sure that we are following the law. Not only because it makes our days a whole lot less stressful and smoother and effective, we collect more money, we probably make more money, especially for paid on commission and bonuses, but also because we can end up being sued civilly if we do collections wrong. So, the next one, also enforced by their sub-agency, which is the Consumer Financial Protection Bureau. Now, enforcement, as I talked about in the previous video, enforcement is done by the 13 federal courts. That's who enforces the law. That's where the lawsuits come to, and these guys enforce. But also now remember, the Consumer Financial Protection Bureau, the folks in that organization can enforce too. The collections laws were not designed for or to protect businesses. Who has to follow collections law? Well, actually, we all do, except, and this is your next answer, the only group of people actually exempt from collections law. Well, think about it. This is America. Who is the only group of people that never regulates themselves? And of course, the answer is our government. Anybody in the government who is acting within the confines of their position, they're performing their official duties, no matter what level of government, they are free from collections law, period. The rest of us, one way or the other, we have laws to follow, whether it's the Fair Debt Collection Practice Act or the state level collections laws, and each state we're collecting in. Let me just throw a couple laws at you. A collections contact is any collections communication, whether email, phone, fax, in person, etc. Now that's written at the bottom of page number 3 for you. So when we talk collections contact, it doesn't matter whether it's fax or email or phone, it's contact. When we're reaching out to the customer to contact them, that is a communication as far as collections is concerned. A collection activity must be performed to accommodate the least sophisticated consumer. There is a concept in collections that whatever we do, we must do it considering the least sophisticated consumer. This could be somebody that maybe is mentally impaired. This could be somebody that maybe has little to no education. This could be somebody that is from a foreign country and doesn't understand our language, our ways. Whenever we're performing collections, we must always make sure, and this actually applies to lending and things, and we'll talk about that, but in collections, we must always make sure that we clearly state everything so each individual knows exactly what the relationship is, what we're getting into, what we're doing. We've always got to consider and deal with people and consider that least sophisticated consumer. So, for instance, let's say you have a contract. A lot of organizations will say, here, read this and sign it. What if the person can't read? Are they going to tell you? Or do you think maybe they would be embarrassed to tell you and they just sign the thing and then now they don't even know what they signed? Collections law and also lending and extending credit law, we always are required to consider and deal with and behave in accordance with the concept of the least sophisticated consumer. An attorney performing any collections act are regulated by the Fair Debt Collection Practice Act. So what happened is attorneys were found to be doing the same crazy things as say, third-party collectors and even original creditors. And that's why an attorney, if they're doing anything with collections, they are automatically included under the, or regulated by the Fair Debt Collection Practice Act. So what does this come down to? Collectors, original creditors, attorneys, everybody has collections laws to follow. The only ones exempt are the federal government.